Hey there, estate planning attorney Paul Rabelais, and in this video we're going to talk about 7 estate planning misconceptions. So here's the deal. There's a few things that people come in, they talk to me about their estate and everything that's important to them and how they want to do things for their spouse, for their kids, sometimes for their grandkids, what protections they want. And sometimes they have some fairly elaborate plans, but they're based on some misconceptions that are in their mind. And it's of no fault of their own. You know, there's a lot of barbershop, rules out there where men get around and talk about all this stuff. There's a lot of beauty shop rules out there where women get around and talk about all this stuff. And a lot of coffee shop rules. But I really don't like it when someone comes in and they make some plans based on some assumptions that are just flat out wrong. And I don't like it because I have to, quite frankly, I have to tell them that they're wrong. And either I have to bluntly tell them that they're wrong, or I have to kind of sugarcoat and dance my way around it, depending upon what kind of person it is. Because I don't know whether they're the kind of person who, when I tell them that their assumption is wrong and they're operating under one of these misconceptions, I don't know if they're the type of person who's going to kind of never admit they're wrong and then kind of justify why their misconception really isn't a misconception, or whether they're the type of person who's going to say, "Wow, Paul, I'm glad you corrected me there. That's why we came to see you, because we know, kind of you're the expert there," is what they say. So let's go through these 7 and, I'll dig into each one of them and explain why the misconception is a misconception. Misconception number 1 is when somebody says, if I make a gift of larger than $15,000 to somebody, there's going to be some tax due. All right, so let's take a look at that. Yes, we do have something called the $15,000 present interest annual exclusion. Many people think that if a gift to someone is in excess of $15,000, some people think the person who makes the gift has to declare that as some type of taxable income. Some people think that the person who receives the gift has to declare some or all of it as taxable income. But here's the deal. Let me give you an example. Let's say dad writes a check to his son for $115,000. And it really doesn't matter what it's for, but dad writes the check, gives it to son. Clearly a gift. Son deposits it in son's bank account. It's a gift. No question about that. What are the tax consequences? Well, the tax consequences are, it is a gift in excess of $15,000. Who owes tax? Nobody owes tax. What dad has just done is dad has used $100,000, the amount of the gift in excess of $15,000, because the gift was $115,000. Dad has used $100,000 of his $11.58 million estate tax exemption. So if after dad makes that gift, dad dies, he can only exempt $11.48 million from the estate tax instead of being able to shield $11.58 million from the estate tax. Dad has nowhere near $11.48 million in his estate. So the gift in excess of $15,000 doesn't trigger any additional tax. Yes, dad must file what's called a IRS Form 709, the gift tax return that is due on April 15th of the year following the year in which the gift is made, but there's not going to be any tax that is due with that return. It's just an informational return to show the IRS that dad used some of his $11.58 million exemption. That's misconception number 1. Misconception number 2 is when somebody says to me, maybe after daddy died, "So Mr. Rabelais, daddy had his will done, so there's not going to need to be any kind of probate." So, sometimes people want to kind of argue with me about that. And they're like, "Yeah, we don't have to go through probate. Daddy, here's daddy's will right here. And daddy left his entire estate to me and my sister. And he named me and my sister as the co-executors. So no need to do any probate. I tell you what we'll do, Mr. Rabelais. We'll just take his will to the bank. I'm sure they'll give us his money. We'll take a copy of his will to the brokerage firm, and I'm sure they'll give us his money. And then, you know, we want to sell his house, and we'll just bring this will down to the courthouse and file it. And that way we'll be able to sell his house. And so really, I'm like, dude, there ain't nothing further from the truth. And we just have a system in place where it ain't that easy under those circumstances. Now that daddy has died, all of his assets are frozen. Look, you can, if you don't believe what I'm about to tell you, just take his will to the bank. Take his will to the brokerage firm. Go, you know, I want to say don't record his will at the courthouse because we need his original will to do it the right way, but bring a copy of his will to the courthouse. You're not going to get anywhere. Yeah, you may get, or you will get access to his IRA where he named a beneficiary. You will get access to his life insurance policy where he named you and your sister as beneficiaries. But you're not going to get his frozen accounts, and you're not going to be able to sell the home, because we just have a system. When somebody dies with assets like that in their name, there's a court system in place where judges must get involved, and quite frankly, attorneys must get involved. And there's a mechanism whereby through lots of court filings and typically lots of delays, judges have to get involved. We have to follow the proper procedures. Judges will get involved to validate, you know, the will, make sure it's a valid will. Then there'll be lots of inventories and lists of assets and other court pleadings filed that will be prepared by lawyers and signed off by you and your sister. And then at the end of this court proceeding, a judge will sign a court order ordering that, you know, that the following assets that are listed in that order be transferred to you and your sister. And then we'll get a certified copy of that order to the bank, to the brokerage firm, recorded in the real estate records. And that's what's necessary to get dad's assets transferred to you and your sister. So the whole daddy had a will, we don't need to do a probate, is a misconception. In fact, there's a saying that's, you know, where there's a will, there's a probate. Sure, a lot of people out there in America, in order to avoid that probate, they established that revocable living trust program that could, if done properly, keep the family out of the court and attorney involved probate. But having a will doesn't keep the family out of probate. That's misconception number 2. Misconception number 3 is, you know what, Mr. Rabelais, if I put my son's name on my checking and my savings account, and if my son gets sued, they can take all my money. So I've heard that a bunch. And, you know, a gazillion people out there, a gazillion parents, regardless of what attorneys have told them, those parents have taken their child to the bank and added the child as having signature authority on the parent's bank account. And it may be a checking account, it may be a savings account, it may be CD. So I want to, you know, some people say, well, I heard that if my son gets sued, they're going to take all my money. So let's dig deeper into that. And, you know, it kind of makes my blood boil when I have to hear that and I have to explain all these things. So let's take a look at it. Okay, so let's say you do put your son's name on the checking and the savings account. And let's say your son, somebody does file a lawsuit against your son. Because somebody filed a lawsuit against your son doesn't mean that they can come take your money. It doesn't mean that they can take his money. But let's say a couple of years later, they do get a judgment against your son. And then a few months or years later, they start collecting on that judgment. And at that time, it's, you know, there's a court process for that. Then your creditors can then seize your son's assets. Now, the fact that you have a checking and savings account that is your money and your social security number is listed on that account. Your income goes into that account. When the bank sends a 1099 at the end of the year to report the interest on that account, they send that 1099 to you and to you only, because your social security number is on the accounts, and the bank knows and you know that that's your money. Your son has signature authority. He can access it, but it's not your son's money. So if your son's creditors get to the point where they can seize your son's assets, then now you may have to prove that it's your money and not his money, but they can't, your son's creditors can't take your money. Now, to take it a step further, let's say your son's name is on your checking and your savings account, and then your son does get sued. Well, you know what? It's going to take, every case is different, maybe 2 or 3 years or longer for the plaintiff who sued your lawsuit to successfully get a judgment and successfully go through that seizing the assets process. So if you do put your son as a signer on your checking and savings account, and there is the threat that your son is going to get sued, just so that you won't have to prove that your account is your account and it's not your son's money, well, maybe that's the child who shouldn't be on your account anyway. Maybe you take your son off, or you open up a new account, and if you really want somebody on that account because you want them to pay your bills if you get sick or if you go to the nursing home, or you want that other person to be able to, pay for your funeral out of your money when you die and not out of their money, then maybe somebody else should be listed as a signer on your bank account. So there's a lot of stuff there, but I think a lot of people think, you know what, if I put my son on my bank account and somebody files a lawsuit against my son, I think people kind of mistakenly believe that the day after the lawsuit is filed, they can come clean my bank account out. That's just a misconception. All right, misconception number 4. Or where are we? Let's see, I got a list here. Misconception number 4. My estate, is when you're asked by perhaps the lawyer or perhaps by your financial consultant or advisor, have you ever engaged in any kind of estate planning in the past? And the misconceived answer is, don't worry about that. We got that covered. I got a will. So some people think getting a will is kind of putting that comprehensive estate planning program in place. There are many estate planning issues that have nothing to do with your will. Things like making sure tax is reduced as these assets transition from one person to a spouse and then to the next generation, and maybe even beyond that. For some middle-class seniors, they are concerned about how do we take action now to protect assets if we get sick and need nursing home care in the future. For others, it's what do we need to do if we get sick and we're not able to sign our name and pay our bills and access our IRA, or sell our home, or sell a vehicle that's in our name. Your will has nothing to do with making it easy for trusted family members to be able to take care of those things if you become incapacitated. Sometimes people want to really keep assets in the bloodlines for the next couple of generations. For others, it's how to best handle the retirement accounts, and the will has nothing to do with that. So, and much, much more. So there's many components of the comprehensive, customized estate planning program that have nothing to do with your will. So having a will is often not even, is just the start of that estate planning program. That's misconception number 4. Misconception number 5 is, Mr. Rabelais, Mama died last week, and we're not sure if we got to do a probate. We're pretty sure we don't, because Mama had a beneficiary on all her investment accounts. Mama had 3 accounts at Edward Jones, and she had a beneficiary on all those. So you don't even need to ask us about that, Mr. Rabelais, because we're going to take care of that outside of your office. And so, I hear that, I say, great, fantastic, you don't need me for that. But in the back of my mind, I'm saying, okay, she had 3 accounts at the investment firm. She probably, and I'm thinking to myself, she probably had a traditional IRA. She may very well have had a Roth IRA. And then she likely also had an individual investment account. And the kids think, because they went to Edward Jones with Mama and they saw Mama fill out a whole bunch of beneficiary designation paperwork, so they're working under the misconception that all of Mama's accounts have beneficiaries. You know, no problem there. They don't need me or a lawyer or certainly any judges to get access to all of the investment company, or as I call it, the Edward Jones money. So in reality, I've seen it a million times. You know, on revisiting all of that, the financial advisor, the children, the family wind up realizing that, wow, yes, the children as beneficiaries can get access to that traditional and Roth IRA. The individual brokerage account is frozen, and nobody's going to get access to that without the appropriate court orders being obtained, submitted to Edward Jones. Their legal department reviews all of the court orders that families have to get lawyers to get. And then after that, then the family can get access to the individual brokerage account. And that's maybe even more so here in my state of Louisiana, where in many states they have these TOD, transfer on death designations, POD, payable on death designations, even for individual brokerage accounts. But those designations are not recognized for residents of Louisiana. So those individual brokerage accounts are frozen if they were in an individual's name when the individual died, and there's no getting around going through the probate process, which means you got to get lawyers and courts involved and get the appropriate court orders for the survivors to get access to those funds. So that's misconception number 5. Misconception number 6 is, you know what, Mr. Rabelais, my wife passed away, and I don't think I need your help with any of these joint accounts we have, because they were joint accounts. In fact, our vehicles were titled jointly and our house was titled jointly. So, you know, I don't think I need you to help me do anything. And of course I'm saying, well, great. He's working under some misconceptions here. Yes, while wife may have had some IRAs, named her husband as the beneficiary, and husband and wife may have had some joint bank and credit union accounts that the bank and credit union will allow the husband to continue transacting those accounts. None of that gets frozen. However, on the investment account, you know, at the Edward Jones, Fidelity, Schwab, Merrill Lynch, all those, the joint account there, at least the wife's half of that account is going to be frozen, and the husband is not going to be have access to it. And certainly the vehicle and the home that is in both of their names, that husband is not going to be able to sell or trade in the vehicle, and he certainly isn't going to be able to sell the house without going through the court process. And you know, some people are so used to the joint bank accounts where when one dies, the other has access. They think it's the same for jointly titled vehicles and real estate, but it's not. You've got to go through the court proceeding to get that deceased spouse's name off of the title. That's what clears up the title so that the surviving spouse and perhaps other heirs can then transact or sell those assets. So be aware that there's different rules for joint bank accounts and credit unions, which are kind of lax, than there are for joint investment accounts, real estate, vehicles. And again, here in my state of Louisiana, we don't recognize when that real estate or when that investment account is titled husband and wife, joint tenants with rights of survivorship. We don't recognize that here in Louisiana, so that deceased spouse's half is always frozen. Got to go through the courts to get that deceased spouse's name off of the title. And again, there's ways you can plan ahead to avoid all that. Many people use living trust. They title all those assets in the name of their living trust. Things in the trust don't have to go through the probate when they die, but I'm working under some some scenarios where a trust did not exist and things are in those couples' names. All right, misconception number 7, and it's kind of focused on my state of Louisiana. You know what, Mr. Rabelais, we're going to go ahead and get access to Daddy's bank account and get his car transferred using the small succession affidavit. And then I'm like, okay, well, did Daddy have a will? Yeah, Daddy had a will. We got it right here. Here's how we left everything. Well, there is a mechanism where people can avoid the formal court proceedings when someone dies if they had left less than $125,000 in assets, but it also only applies if Daddy didn't have a will. But if Daddy had a will, you got to go through the formal court process to get things transferred. So it's a misconception that people think they can use this simpler small succession affidavit procedure when the deceased person had a will. All right, so you know what? I said 7 at the beginning, 7 misconceptions. So there's your 7 misconceptions. Boy, if everybody who came into my office knew all of those 7 things, and I'm not saying that they should, because people don't do estate planning and have estate planning discussions every day, but it sure would make my life easier if people came in, and maybe that's one thing this video will do. It will, for some people at least, the people who watch the video, it'll eliminate this kind of these misconceptions from their thinking, so they can realize it and then make plans moving forward. Because estate planning can be complicated, but the more misconceptions that you can eliminate, the better position you're going to put yourself in to provide for an easy and cost-effective transition without complication and difficulty. One last really important misconception is people make the mistake that they can be well educated without hitting the like button or subscribing to this channel. Big misconception there. Make sure if you haven't already, hit the subscribe button and the notification bell so you don't miss anything. Hit the like button. YouTube will keep letting you know. I got some videos out there as I crank these videos out from an educational standpoint on a regular basis. Y'all have a great day. We'll see you next time.